indicating that Mr. Mafum is not fit for duty as a member of the police department. Other statements we've researched that indicate they're not accurate. Indicate he's had marriages for profit to help folks gain visas. We've, of course, before Mr. Flynn was hired as a police officer, we conducted a thorough investigation in his background. Since this has arisen, we've further delved into the background to confirm that many of these statements, all these statements appear to be misleading.
Again, they're talking about me, Khalil this. He's not shouldn't be hired. He's on the Brady list, which I'm not, Your Honor. I've never lied to court on any of my cases, making him a liar, liability to any case he touches. This is also in the post that she posts online. She posting all my business, my private life. She's going looking up my deed. I own a property in New Hampshire, Your Honor. I am
How do you know she's doing all this?
Your Honor, because she's literally attaching these things to the email, stating that I'm violating residency requirement for police officers. She's going and found my deed. I just refinanced the house, trying to renovate the home so it'd be available for rent. We have a family member interested. All of these things, constantly looking up where I am. I'm at a new address right now, but I am so afraid that she would find out and
the notion that they have failed to state a valid claim. Okay, thank you, Your Honor. So, Judge, everything they've said is pretty much an admission to violating the anti-SLAPP statute, which is, for the record, 231-59H, where you would try to suppress someone's rights to petition the government, to notify the government. I don't see how, Your Honor. She hasn't contacted him. His own admission is since 2022, she hasn't contacted him. So here she's petitioning the government. It's literally in the First Amendment that she can petition the government. She's petitioning the government on her behalf. It might not be something that you would do or I would do, but the question is whether it's protected, and it's 100% protected activity.
Is she petitioning the government because of a government policy or a government proposal or something like that?
So
she's petitioning the government because those government agents or authorities are his employer.
So she's petitioning the government. She doesn't it's not like what's her real intent is not really part of the equation, Your Honor. It's can you do it? And so she can petition the government under the First Amendment. Number two, we have to look at the framework of the threats of the 258E standards. So she's engaging in the most highest protected criminal activity, petitioning activity that she can possibly engage in. It's literally in the First Amendment. She has the absolute fundamental right to petition the government. Absolutely. So she's doing that. So whether it gets her some benefit or doesn't, or it is not part of the equation. The issue is under 258E and O'Brien v. Borowski, which I'm sure the court's familiar with, it has to be threats or fighting words. And here, there are no threats. And it says right in O'Brien v. Borowski that it's not like, oh, she's threatening to sue me. She's threatening to get me in trouble with my boss.
How about a threat of economic demise?
It's not there, Judge. It's a criminal threat. It's literally the legal definition of threat. And so she's threatening nothing that is actionable under 258E. And it's right in O'Brien v. Borowski. The threat has to be a threat, like a true criminal threat. It's not a subjective fear. Oh, I'm afraid she's going to embarrass me. I'm afraid I'm going to get in trouble with my boss. I'm afraid this, that. That's not the fear that is actionable under 250D, and that's right in O'Brien v. Borowski. It has to be either where speech is the basis for the violations, which obviously this is emails. It has to be a true threat, and then that's actually the words true threats is from the Supreme Court. It has to be a true threat or fighting words, which fighting words isn't really applicable here. There's no fighting words. There's no immediacy of anything here. And so she's never contacted him. She has, she knows from his past that he's on the post commission. She knows from the past a bunch of other things that I'm not going to just throw out there to smear him. But regardless of what it is, she's acting on it to government officials. And that is completely protected activity, Your Honor. And again, you might not do it, I might not do it, but she can do it. And the idea that they can file this to suppress that is completely wrong and complete an absolute violation of the anti-SLAPP statute, and it runs completely afoul of O'Brien v. Borowski, Your Honor. And I can see how the court, in an ex parte fashion, with all kind of the bells and whistles that you heard, would issue something. The attack, the assault, the verbal assault, the weaponizing of this. It's just, I'm sorry, but it's just not anywhere near any of these types of activities. There's not even one of them, and of course they need three of them. So if the gentleman feels that my client is lying about him, he has the ability to sue in civil court. He has the ability to say that she's slandering him and lying about him. And so there's been a series of things that have caused her to feel this way to do this, and she can do it. And it's not threats, it's not fighting words. And I ask you to deny the motion, the request for the order, Your Honor.
All right. So what, sir, would you like to say something briefly?
Your Honor, I just have my wife. She likes to testify to one.
No, I'm all set. But thank you anyways. So here's what the court's going to do. I'm going to take the matter under advisement.
We have all the parties to do that, Your Honor.
Thank you. All right. Good morning, Mr. Mafum.
Good morning, Your Honor.
Good morning, Mr. Bay, and good morning, Attorney Bradle.
Good morning, Your Honor.
So I appreciate your patience, and I did have the opportunity to review the law, and the law is quite clear. Mr. Mafuma, I want to make this clear to you. You're not represented by counsel, but I want to make it clear that under the statute and under the case law that's that works to understand the statute, it is clear that the types of actions Mr. Bay is engaged in against you do not qualify as harassment under the statute. The case law, specifically two particular cases, mention what true threats are and how the true threats and fighting words are excluded from constitutionally protected speech. What has happened here is that she's engaged in actions that are outside the law, outside the I guess exceptions to constitutionally protected speech. So when you, Mr. Fum, speak of your fear, the fear that's engendered by her actions, that fear being, I guess, fear of economic loss, fear of you're losing your job because of what she's done, that doesn't qualify as an act of harassment. Case law has specifically said that your fear has to be a fear of physical harm or fear of physical damage to your property, and you haven't expressed that either in court or in your affidavit. And specifically, case law says that that fear must be more than a fear of economic loss. So, as I said, the acts, while they're certainly disturbing to you and upsetting to you and troubling, to say the least, given the length of the time that they've been going on for and the kind of widespread targets that they've hit. Unfortunately, it doesn't qualify. So the court will terminate the order.